everybody. We're just chiming in here to welcome you to this webinar. It's Sonia Vanni here from the Federation for the Humanities and Social Sciences. Welcome. We've got a few of our participants already logged on. We're expecting a few more to log on, and we are expecting to have representation from across the country. So from coast to coast, hi to you guys, and a warm hello from Ottawa. We're in the Federation boardroom, and we're joined in person by Stéphane Aymar-Chabot from the University of Ottawa, who's sitting right here on my right. And to my left, I have Philippe Cyr, who's our Member Relations Officer. And hovering about, we have Lorna and Lily, who are part of the team and who have been helping us with the logistics to bring you this webinar today. So to all of you, thank you. And we'll be starting in just about maybe 1 minute or so. So hang tight, we'll give it another minute. Great. All right, we're back, everybody. We have a couple of other people who have joined us. So welcome to all of you. You're at the right spot. We're going to launch ourselves into an introduction to defamation law. It's a wonderful thing to do on a Thursday. So thank you for taking the time to join us today. One quick moment. All right, we'll just be 1 second. All right, so in terms of today's agenda, we're going to run through fairly quickly a couple of housekeeping points for your attention. We'll introduce you to our speakers actually. We'll be introducing you to two people who are very seminal in pulling this together. And then we'll run through the presentation, and you'll see that the presentation is structured in such a way that as formal content is presented to you, we have a guide who's going to help us through it and who will be asking questions of our experts to kind of guide participants along. So this is we found it was a very engaging way to go through the content, and we think that it will be suitable for the participants to kind of run through and maybe answer some of your own questions that perhaps you have around this. And of course, following the presentation, there will be an opportunity for you to ask your own questions. And that brings me to our next slide, which is really about housekeeping and how you can use your chat box to ask questions, of course, at any time. You can use your orange arrows to show or to hide the chat box. And you can go to our website, ideas-id.ca/webinar/troubleshooting to get more information on whatever you might be experiencing from a technical standpoint if you're experiencing any difficulties. We should also note that the slides will be shared with participants shortly after the webinar. So if you're trying to take a bunch of notes, don't worry about it. We will circulate the slides with all participants. And also a little reminder, in case you did not come across the resource material that was prepared for this, that it is available under your handout box through GoToWebinar. So you should be able to access a nifty handout, and we produced it in English and in French with the help of our expert, Stéphane. So it is there available for you. If any of you have any questions that you feel cannot be answered, that are of technical nature, or you're having some kind of issue either hearing us or following along, please use your chat box and we'll do our best to answer questions as they come in. We're just going to pause for just a short moment. So just in case some of you have not seen the slides advance yet, we're aware that the slides are not sharing. We'll just spend 30 seconds trying to solve that problem, and we'll get right back to you. Please hold. All right, so we're back. I think you should be able to now see the housekeeping slide that we were talking about in terms of using your chat box to ask questions as we move through the presentation. So thank you for your patience there. In terms of today's speaker, Stéphane Aymar-Chabot is a lawyer and a lecturer at the Faculty of Law at the University of Ottawa. And he's been really wonderful to work with and an indispensable resource, obviously. Worked very hard at producing the materials that we provided to you in both official languages. And also, of course, Jennifer Andrews, who is a professor at the Department of English at the University of New Brunswick, and also the president of the Association of Canadian Colleges and University, of College and University Teachers of English, ACUTE. And I should mention that this is a collaboration between an association and the Federation. Jennifer reached out to the Federation and brought up the topic of defamation and how it could be useful to associations like hers to have a bit more information around this. So I think that's where I'd like to kind of start. It's to ask how this came about and how the two of you, Jennifer and Stéphane, have been working on this.
Okay.
And tell us more about this.
Okay. Thank you, Sonia. I just want to say, first of all, we're so grateful to the Federation for hiring Stéphane, for creating this webinar and these handouts. ACUTE actually stands, as you've mentioned, for the Association of Canadian College and University Teachers of English. And we've paid particular attention to the topic of defamation and the need to educate academics across Canada on this issue as a result of concerns that were brought to our organization by our members, some of whom are facing defamation litigation and expressed fears that they do not understand how defamation law works or have any real grasp of its relevance to their work on a daily basis. And I think this is especially true for contract, sessional, and precariously employed individuals, instructors, and graduate students who may not be able to access legal advice through their union or home institution. In addition, as a member of an executive or running an association with a Facebook and Twitter account, myself and my executives became increasingly aware of the challenges we face as an organization, like many others, that shares information across platforms. And selfishly, we really wanted to get some clear directions on how to minimize our liability, yet continue to represent the concerns of our members. So our aim in bringing and creating this partnership with the Federation, which has so generously funded this work and bringing the handout and webinar to fruition, was to give our members, and I think all members of the Federation, an opportunity to become versed in the fundamentals of defamation law in Canada and to create venues where members of the Federation could ask more substantive or specific questions about how it applies to the work that we do. My sense is that education is a critical piece of the puzzle, and we're hoping from ACUTE standpoint, but also I know, having worked really closely with Stéphane, that this webinar will provide members with a starting point for understanding defamation law, but also its real life implications in the context of academic work. And a special shout out to Stéphane for being so willing to answer the many questions that I posed as an academic who is not an expert in defamation law. So I'm very grateful, because I think it's a good pairing and a good partnership to enlighten people who maybe don't work with defamation law or work in the legal field day to day.
Thank you so much, Jennifer, for that introduction. And we look forward to your conversation with Stéphane as he runs through the material.
Thank you.
Hi, Jennifer. It's great to be with you once again. It's been a really fun project to work on, and as somebody who teaches in university as well, I can understand the concerns of your members and the Federation broadly. Where would you like to start today?
I think I'd like to start as on the slide that you pulled up about looking at the Charter of Rights and Freedoms, because pretty much everyone knows that the Charter protects free speech. And this is really a point of confusion, I think, for academics who may presume that we are protected when we publish articles or send out a tweet or even share a post that has been authored by someone else. And as we've discussed previously, the definition of publication is very different in a legal context. And I think it needs to be acknowledged and understood by academics to fully comprehend our potential liability.
Okay, so let's start with what the Charter does and what it doesn't do. And it's not just academics. I think most Canadians think that the Charter is a protection against everything. And in fact, the Charter has a very specific role, and it's important to keep that in mind. The Charter is there to protect us as citizens and as residents of Canada against abuses, actions by the state, the government. So the role of the Charter is really to act as that buffer between actions by the government, the police, legislation, regulations, and so on, and making sure that those state actions don't infringe on our rights. Now, what the Charter does not do is it does not regulate the relationships between individuals. That is not the role of our Charter of Rights. That is really up to private law to regulate interactions between private citizens.
Okay, so that complicates things, right? Because my thinking is, so if my private acts of communication don't fall under the Charter, then is that where defamation law comes in? I guess it does.
That's exactly the role of defamation law. So defamation in legal jargon is considered a tort, and to be clear, that is not a pastry, although it would be nice to have a piece right now, I think. So a tort is a legal wrong that somebody does to someone else. So that's where the whole private law aspect comes in, and that's what regulates communications between people and when a person communicates about someone. So defamation law is where we will find this, and it's that civil private wrongdoing that will then generate liability. And so the role of defamation and the role of this area of the law is really to try to balance two key things: the personal reputation of a person and their private persona, if you wish, and free speech and public debate. And on the slide, you have this really great quote from the Supreme Court, and I'll just read it because I really, really like this one. It says, "An individual's reputation is not to be treated as regrettable but unavoidable roadkill on the highway of public controversy, but nor should an overly solicitous regard for personal reputation be permitted to chill freewheeling debate on matters of public interest." So certainly colorful language from the Supreme Court, but really intended for people to understand what the law tries to achieve with defamation.
So given this, how exactly does the law strike this balance? Because there's this issue of personal reputation, protecting someone's reputation or challenging it, arguably defaming it, and free public debate. So where does that balance come from, or how is it determined?
So the common law has developed a two-stage approach, essentially to answer that question. And the first stage, the first step is to assess, and that's the sort of, if you think of the scales of justice, that's the reputation side of the scales. The question the judges will ask, the question is, were the remarks defamatory? And we'll see what that means in a minute, but that will be the first thing the courts will look at. And essentially there, what the courts are trying to assess is, have you crossed the line between common everyday criticism of ideas, of others, of actions, and so on, and really starting to harm the reputation. And that's a fine line that judges have to draw, and we'll see how they do that. Once you've determined that the remarks are defamatory, then the other side of those scales kick in, and that's the public debate part. And the judges will then ask themselves, well, okay, what you said was defamatory, that really did harm somebody's reputation, but were they justified? Was this a necessary part of public debate? And that's essentially how they're going to go about it in a nutshell.
Okay. So yeah, go ahead.
No, go ahead, Jennifer.
Well, I guess what I'm wondering, I mean, it sounds like it means that I can say or write things that are critical of someone as long as my remarks are justified. But I guess the question that comes up, I know for some of our members, is that what we've seen as an association is the way in which the threat of litigation by using defamation law has been kind of employed as a scare tactic to silence individuals. And it's often women who speak out against harassment, but it's kind of a way of shutting down public debate would be arguably what's happening.
And yeah, and that raises sort of a practical issue, and maybe we can get back to that a bit later on. But the reality is, and this is arguably a problem in our system. There's nothing to prevent somebody from launching a lawsuit, but but understanding what the legal tests are is probably a very helpful tool in sort of gaining power over the issue. So let's move on maybe to the first issue and try to figure out, what is considered defamatory for judges and lawyers.
Yeah.
So the first step is really determining, have you crossed that line between common, ordinary criticism and something that becomes a bit more problematic. And essentially, the person complaining about what was said about them has to prove three things. The first thing is, and this is a legal test, these are the words the judges will use, did the comments tend to lower the plaintiff's reputation in the eyes of a reasonable person? And the reasonable person is a mythical creature in law, and it means that we're not looking at, how did you feel about my comments about you, Jennifer? That's not the question. The question is, somebody listening to my comments, reading what I've written or posted, how would they interpret this in the context? The second thing you would have to prove would be that the remarks, in fact, speak to you and not somebody else. And then the third thing is that the remarks have to be published. So if you are able to prove those three things, that I published something, that it was about you, and that something in the eyes of the ordinary person out there would tend to lower your reputation, then you've established that I have defamed you.
Okay. Yeah, and that I actually think is very helpful in terms of thinking through what the various those first sets of steps are in that test. One of the things I wanted you to say a little bit more about was how the remarks, the third part of the test, the remarks were published. You and I have talked about this, and publishing means something very different in a legal context. So I think it would be really helpful to members to know what that idea of publishing is, because it's very different from what we think of, I think, as academics, of publishing being an article or a book or something that is published through a peer-edited journal, for example, or a newspaper.
Yes, and for lawyers, publication has a very, very different meaning. Publication for the defamation analysis means any communication to a person other than the plaintiff about that person. So the moment that I speak to Sonia next to me about you, I'm publishing something. The minute I tweet something about one of your articles or something you said at a conference, I'm publishing. So even when I'm standing in front of my classroom, if I refer to the decision made by a judge when I'm teaching a law course and I'm critical of that, then I'm publishing. So all those acts including obviously the traditional acts of peer-reviewed articles and all those things, but any type of communication where you speak about someone, then you are considered under law to be publishing content.
Yeah, and I think that's something that is very, for many academics, has never even been something we've thought about. And it's becoming much more important, obviously, because of the way in which the web's used and the way in which news and other issues are diffused and sent around the world globally. And that when we tweet or post, that it has implications. The other thing I was going to ask you about in relation to this, because it's not mentioned in this list.
Sorry, I'm going to interrupt you.
No, go ahead. Yeah.
Yeah, just interrupt you 2 seconds. You may even be publishing unintentionally.
Yes,
if you're giving a lecture and your student is Facebook Live, broadcasting your lecture, that's being sent to the universe, and you really have no control over that. So, yeah. You really have to be aware, as you say, in this digital age, that publication is not necessarily something you're doing, but could be, in fact, somebody else rebroadcasting what you're doing.
And you would be expected to be held, you should be expected to be held liable if someone is, for example, posting or streaming live what you're doing in a classroom. That would still be, okay. That's really important, I think, because it's one of those issues that we don't pay attention to. And I think for many of us who are older and maybe remember somewhat pre-digital age or are thinking, how could this happen? So,
exactly.
What if, it's a whole other world. What about footnotes or references? Because that's one thing you haven't mentioned. But if I refer to a source in a paper, for example, am I publishing that content? Because there are things that I think many of us write about that are controversial, where we might cite something and we may disagree with the content, but we're citing it for the purposes of our own argument.
For academics, that's a really practical issue because your role is to question and move ideas forward regardless of your field. So there is a gray zone for sources. So that could be footnotes or hyperlinks. It could be retweeting something. So anything where you are using the content of someone else as a source or the basis of something, the law typically will not treat that as an act of publication. So if I write an article and I reference a document or a post by someone and that post is defamatory, the law will not attribute that publication to me. I'm using it as a source. I'm using it as an example or to support a thesis I'm developing, whatever it is. The line will be crossed if you appear to, or a person senses that you are endorsing the content or trying to draw attention to it. And on the slide that we can see, there's a good little quote there from the BC Court of Appeal. If you merely transmit information in a content-neutral way without expression, adoption, or endorsement, and those are the criteria. Are you expressing the idea? Are you adopting it? Are you endorsing it? If you're not doing those things, then you're not publishing. So obviously, especially for an English professor, if you're referencing material that may be very controversial or may include content that is critical of others, as long as you're not adopting or endorsing the content and you're using it to further your own opinions and ideas and debate, that's fine. But if you retweet something and you tell people, you should really look at this, then you're probably crossing the line and you're entering the publishing world.
Which is complicated. Yeah, and I think this is a very complicated gray zone to negotiate. Because I was thinking, for example, one thing that strikes me is what happens if I simply want to question something a plaintiff said or did, but I never intended to attack that person's reputation? Would that not make a difference?
That's a really good question. And again, in the first phase of the analysis, whether what you published was defamatory or not, your intention really does not matter. And in law, we call this an objective test. It is not, we're not trying to get into the mind of the person who said or wrote or tweeted something. We are looking at it from the outside, using that mythical reasonable person I mentioned earlier. And we're trying to appreciate how an average person in society who looks at the whole context would react to this and say, wow, this is really bad. or this is simply critical. So what you intended is not a defense in the first part of the analysis. In determining whether what you said or what I said is defamatory, the judge will only look at what the objective impact of those words are.
Yeah, which often takes it out of a context that seems could seem very reasonable and important to an academic, but may not apply in that first set of tests when you're putting something forward. So I just want to make sure I understand the first step in the legal analysis. If I say, tweet, or write anything critical about someone, and my remarks might tend to lower that person's reputation, as we saw quoted, I might be defaming that person. And to me, if that's the case, it sounds like a pretty low threshold. So then how can there be freewheeling debate in this context if you've got this kind of very low threshold for moving forward?
So that's where the second part of the equation, or the other side of the scale, if you're more visual, that's where that comes in. And these are what we call in law the defenses, in layman's terms, more justifications for what you've said. And there are three key ones. So you can say, just to be clear, you can say something defamatory as long as you can justify it under one of these three headings. And there are a few more, but the key defenses for our context would be this. So first, if you're speaking about facts, and in law, thankfully, we are not in the Trumpian world yet, and there are no alternative facts. For judges, facts are still facts, and Canadians can rely on that, which is helpful. So if your remarks are true, entirely true and objectively true, then you can say whatever you want. And so it can be very harmful to a person's reputation to bring up something that is true. But regardless of the impacts, if it's true, you're allowed to say it. You're allowed to publish it, to be clear. The second one is opinion. And for lawyers, we'll call it fair comment. And again, you are allowed to express whatever opinion you want, as long as your opinion is to some degree based in the facts. So, and there is here, and that's where the freewheeling debate comes in, there's a good range there for people to express opinions. And even marginal opinions will be protected. They will not be protected, and this is where the intent comes in. If you're expressing an opinion, and I can show that your opinion about me was expressed purely out of malice, you intended to harm me, you can't raise the opinion defense and say, oh, I'm just expressing my view on this. You can't express views if your intent is to harm. So you can express pretty much any view if you have a factual basis and your intent is not malicious. And malicious is really, mean-spirited and so on. So those are the two big ones. And there's a third one, which applies more to journalists, but has some relevance in the academic field. And this is the newest defense that the Supreme Court has created. And if you communicate on matters of public interest, and matters of public interest are not things that are popular. So, whether or not this star broke up with that star, that may be of great public curiosity, but it is not of public interest. Public interest means somebody has a genuine stake in the information. So, if I'm publishing something on some obscure aspect of the law and 5 other lawyers in the country have a genuine interest in this, then that's a matter of public interest.
Interesting.
And if my publication is responsible, so the word responsible, as long as I've done my due diligence and I've tried to check the facts, then I'm okay. The courts have created this mainly to allow journalists to report on things about, for example, a politician who did something. And the politician can't sue and say, well, that wasn't entirely true. Well, the journalist can come back and say, well, I did my best to check, really did my best to check, and this is really of public interest. You're the prime minister, and we need to talk about this. So, that's why it was designed, but it could apply in an academic context.
So, Yeah, what I was going to just ask is, can you say a little bit more about malice? Because one of the issues I think that, our members have is, or I would, as someone thinking about where our members are coming from, you've said, it does, malice is kind of doing harm, but how do you determine that in a legal context? Like, how is that assessed in a legal context? I don't know if there's an easy way to explain that, but.
Yeah. You get into, so malice is really a state of mind, and that's where it gets tricky. But judges will have to look at the evidence, in what context was this published, what other words used, what was the audience, and determine, and that's the judge's call. They will determine whether they think you had a really mean-spirited intent. This is more than being critical. I can obviously express an opinion about your work, Jennifer, and say, she published this article last week. I think it's really poorly written. I think her sources are bad, and I think she comes to a really unsupported conclusion. That's all fine. I'm expressing an opinion. It's very critical, but it's based on your article. That's completely fine. If I were to go further and know, and this is where the context kicks in, right? I know how significant this is for your tenure, and I'm a colleague and I'm jealous, and I'm really doing this, and it's pretty clear I'm doing this to undermine your tenure. Then you're being malicious. This is more than just debate, right? So it's a tough assessment, and I'm not sure if all my answers are helping, but the judge really has to try to get into the person's mind and see, were you really just being, in the spirit of a healthy, robust debate, or did you cross the line into something much more nefarious? The threshold is pretty high, but it is there.
Okay, so it would be things also like crossing the line into personal matters or information that might be, like you've said, impacting someone's career or trying to ruin someone's reputation, those kinds of things. So that makes actually, I think, a lot more sense. I think that's really helpful. And obviously it would vary on a case-by-case basis and would be context specific. Exactly. So that's part of the challenge. Okay.
And if I could just recap, so test one is, have you published something that is defamatory? And then test two is, can you justify those things either because they're true, because you're expressing an opinion that's based on fact? That's how the mechanics work.
Okay. Great. What about the concept of academic freedom? Where does it come into any of these defenses, or does it?
So that's a good question. Up until now, the courts haven't given that concept a specific place. So it's been considered a bit in the notion, and it would probably fall into the sort of the breadth of the opinion you could express. So as an academic, your job is to, at times, be critical. Obviously you're advancing your ideas, but you can be critical of ideas advanced by others or the research done by somebody else. So I would say it would be a very important element of the context, to assess the opinion and so on, and maybe even in the first stage to assess whether it was defamatory or not. You can say, well, I'm not defaming. This is part of my job, but there's no specific place in the analysis for academic freedom. It's not a specific defense. It is just part of the context that the judge would consider in her analysis of step one or her analysis of step two.
Okay. Yeah, which I think is important to kind of keep in mind, because I think we tend also to think of academic freedom as creating a broad swath of possibilities. And sometimes that's not in fact the case. At least in a legal defense, it sounds like if it's context related rather than specifically part of those two tests, it's not as pivotal as we might think. In thinking about defamation.
No.
So
you can't go in front of a judge and pull the academic freedom card. That's what I'm thinking. Okay. And that's important to know, because I think there is a sense in which academics are pushed to
challenge ideas, bring about new ideas. And so there's a sense of kind of, that there are contexts that we aren't aware of in a legal sense that may not make it as straightforward or as easy to be engaged in these kinds of things as we first think. So what about, you were going to talk a little bit about what to do in terms of a lawsuit, and I was interested to see what you would suggest. Where do you go, or what do you do when this comes about, either as someone who's been facing litigation or someone who has been defamed?
So if you get sued, so there's a few things to consider. The first thing is the immediate response. If you get a letter from a lawyer threatening a lawsuit, or if you get a statement of claim actually suing you, the worst thing you can do is ignore it. Denial might be comforting, but it is not practical. So the key thing is to send a response as soon as you can, letter, email, whatever. Say, thank you, I've received it. I'm seeking legal advice, and my lawyer will contact you. And that will buy you time. And typically, from a professional perspective, the other side will wait until they hear back from your lawyer. The next thing will, frankly, be to reach out for personal and professional support. Professional, first thing obviously will be to look inside your organization, whether there are mechanisms to support you there that are formally established. If you're part of a collective agreement, contact your union. There may be provisions there. Contact your employer and look into those things. And I'll talk about the employer role a bit more in a second.
Right.
On a human level, frankly, the key thing too is to get personal support. A lawsuit can be a long affair, even if it's frivolous and unjustified and you're being wrongly sued. It will take a while to clear it up. So building a network of support around you is really key. Friends, family, and obviously people at work. On the employer side, just a couple of things. If whatever you published, in the legal sense, was done in the context of your work, then your employer could be liable. Employers are typically liable for the actions of their employees in the context of their duties. So your employer will have a stake in this. And I've seen cases where the employer, in fact, takes over the whole defense because they want to make sure that they're not going to be on the hook for it. So it's always good to get your own lawyer, but often the employer, because of their stake, will want to play a very active role in the file. And that's something that you, your lawyer, will discuss with your employer. And obviously, if there's a union element as well, that will have to be factored in.
Okay. What, just as an aside, what do people, because we've had instances where members have contacted us and said, you know, I'm not getting good support from my union, or I am a graduate student who's also a contract employee. My union seems not that interested. My status as a grad student precludes me both financially and in terms of how I'm situated in the university from getting much support from the university. So what are some other options? Because you and I had talked a little bit about what are some of the other things that people can do, or places that people can go to look for support.
Right. So first off, on the employer side, this is a binary test. You are either an employee or you're not. And if you're an employee and what you did in the context of your work is the issue, then your employer has a stake in this. So it doesn't matter whether you're a grad student, a tenured part-time lecturer. If you're an employee, your employer will have a stake in what's going on. They may try to say they don't, but they certainly do. The union obviously is such a case-by-case basis. Even within an institution, collective agreements can vary. So you'll have to check there. But most larger communities, and doesn't have to be a big city, but most communities do have legal clinics. So if you're a grad student and you don't have much money and your union says, sorry, we have no stake in this, which is possible, then that would be a good place to turn to and try to get some advice to help you move forward on this.
Yeah. And obviously, I mean, part of the reason Acute became involved was trying as a professional association to also advocate for members and to reach out to other groups, places like CAUT, to say, hey, this is an issue that needs to be supported at all levels of study. So yeah, but I think the legal clinic is a really interesting and helpful place to send somebody who may be looking at trying to hire a lawyer and may be very fearful or intimidated by the fact that lawyers generally are expensive and that they don't necessarily have the money or the resources to do that. And that, again, like you said, the immediate response as a defendant, I think, is an important first step, but then knowing, okay, where do I go next? Because often my sense is the part of the intimidation of being a defendant is knowing that you may be in for a legal battle that will be expensive and being fearful of that.
Yes.
So,
and that's unfortunately, that's the reality of our system, and it is. I mean, that's you know, we could go for a beer over this one, but yes, law is not a cheap undertaking.
Yeah. What about as a plaintiff?
So, as a plaintiff, that will depend as well. So, there are cases where a professor was defamed because of work they did, and the institution took over the full defense. So that has happened. Now, as far as you suing someone, there are also examples of that. Obviously, this is a private remedy, but if it was in the context of your work, again, depending on your collective agreement, but there may be an argument to be made to have your employer, in fact, initiate the lawsuit, because your defamation is, in fact, the equivalent of a workplace injury. Okay. You were asked to undertake a report, you undertook the report, you published it, and you know, somebody's saying horrible things about you because of that report, then you may want to defend your reputation, and the institution may support you. Again, that's very much a case-by-case basis.
By case basis, okay.
I'm going to jump in.
Go ahead.
I'm going to jump in with a question that came in through the chat box.
Oh, great. Thanks.
What about students who claim that a professor was racist in class, perhaps in that person's way of teaching? And then the students write an article on the matter, which shows their perspective.
Great. And
then they send out that article on social media. And the person asking the question says that we receive a few such complaints, such as this, and oftentimes they're CC'd. There's a CC they're CC'd by the complainant. So
interesting.
Can you say anything about that?
That's a great question. Yeah, Stefan, you respond to that first. Yeah.
Sure, and then you can give, you know, from the academic point of view, how you feel about that. So obviously, the act, what the student did is obviously an act of publication. Does it cross the line into defamation? I would say arguably that there is a case there that this is defamatory. So then you have to move on to the second piece of the test. That's how the mechanics work. Was that opinion based on fact? And so that will obviously depend so much on the context of what was said, how the behavior took place, and so on. But if you are an academic and somebody is accusing you of being racist, homophobic, sexist, I mean, the list of things, it may be very critical, it may be harmful, but depending on what you said, the person may have a justification. If they don't have a justification, then it is your decision, and that's what we were discussing just a few minutes ago. Do you initiate a lawsuit? Do you try to correct that harm by launching a lawsuit? Or do you turn to your employer and say, listen, I'm being defamed because of my work, and I want my institution to back me up. So this is again, as I said, the equivalent of workplace injury, right? Construction worker will break a leg, you are being harmed in a different way. So it is so fact specific, but at the end of the day, frankly, and you know, I'll take the pure legal hat off. There is a very practical aspect of, is it worth launching a lawsuit? Lawsuit will take months to resolve, if not years. And what is the harm you're alleging, right? How broadly was this broadcast? How credible was the source? So you may be legally completely in the right, but from a practical perspective, is this really worth it? So yeah, that's a tough call to make. But and in today's, and I think the law has some catching up to do there, because the law is adapting to modern technology, but it is so much easier today to say horrible things about people, and we see it all the time. Politicians who receive death threats via social media. It's become very easy, and in the political context from the South, it is in fact legitimized in many cases. So the law, I think, hasn't caught up to that yet. So the practical aspect would say, is this really worth it? Yes, this is harmful. Yes, this is crossing all the lines. At the end of the day, what am I going to do about it for really?
Thank you. Thank you, Stefan. Did you want to share a brief opinion on that, Jennifer?
I don't think so, because I mean, my sense is what Stefan said makes sense legally. And I think one of the challenges is that universities, I think in many cases, are still trying to figure out also how to negotiate those kinds of situations where the law hasn't caught up to the way in which things are circulated online. And there are instances, we see this in the press with relative frequency, where students, make claims about professors, and they're not always wrong on them. They're in many cases telling the truth of the matter. But part of it is, to what end are you going to pursue a legal recourse? And where does your university stand on it? And I think it's a really difficult thing to deal with, because one of the issues that's often been a challenge in universities is who adjudicates these kinds of things, because they really are within many of the discussions happen within universities and really beyond a legal context, and outside of a legal context. And it's hard also with collective agreements to know what to do with material that has been brought in, for example, through student opinion surveys or through student experiences. I mean, one of the biggest issues around that, and this is quite separate but useful to know, is that often when student opinion surveys come in of teachers, women and those who are LGBTQ+, ethnic and racial minorities, visible minorities, are often given much lower scores. So there's that kind of catch-22 of what the context is, what's happened, what's been said. But I mean, it's important also as a professor, I think, to take responsibility for what you say in the classroom and to give adequate context. And that's something that takes a fair amount of skill when you're talking about difficult issues or complicated issues. But I see it as almost separate from the defamation piece, because the defamation piece really requires, I think, a fair bit of legal knowledge and whether you're really wanting to be engaged in that. But it's a great question, and it's one that I think is going to be ongoing.
Yeah, and I look back to, for many, many years, I was assistant dean at the law school, and part of my responsibilities was student discipline. And for this type of behavior from a student, I think administrative remedies are typically better. A good, robust code of conduct on how we agree as a community to interact with each other with penalties is a much faster remedy, much healthier typically, because it can include some kind of alternate dispute resolution, some kind of face-to-face mediation if it's appropriate. So the law is a pretty rigid frame to deal with things like this. And I think administratively, for members out there who are concerned about this, working within your institution for robust mechanisms within your shop is the best route to deal with this type of new issue of people being able to essentially tweet, post, Snapchat, anything they want, right?
Great advice.
I would totally agree.
We've expelled students for that, right? So that's the remedy. Much
faster. And it creates a
being
better.
in court for
the other thing
5 years.
too. sorry, Stefan, is it creates a better culture too. I mean, universities, if you're trying to change culture and create a more open and kind of engaged culture, part of that is allowing people to think through difficult issues, and there needs to be supports for that rather than shutting it down.
Yeah, and it's important, as you know, especially as teaching institutions, to have that discussion. Given all these new ways of communicating, then what's our social contract? What do we agree on as proper behavior? Right?
Yeah. So, Sonia, are there other questions?
We'll move on and I think wrap up the formal part of the presentation. And if there's any time left, we'll get to any other questions.
Yeah. I think the last thing I was going to ask Stefan about was just about hate speech, because I think it's something that might come up. I mean, there are instances where freedom of speech may cross the line into content that is hateful in nature. So how does Canadian law make that distinction, and what relevance might it have for our members? What might that mean?
So a couple of things there. First of all, defamation law deals with private remedies for individuals. So it does not protect groups. It was not designed for that and doesn't do that. So the only protections for groups are found either in the criminal code or in human rights legislation. And in the criminal code, you've got the quote there from the code itself on the screen. The threshold is quite high. So I can say anything about a group, pick a group, as long as I'm not inciting hatred against that group, and hatred in a way that is likely to lead to a breach of the peace. That is a very high bar. So anything under that bar, when it comes to talking about groups, is pretty much fair game as far as the criminal code is concerned. However, most provinces, and it does vary, so I can't give an answer for all of Canada in 2 seconds, but if you look at provincial human rights legislation, most provinces will include protections with remedies and penalties for groups. So that's often a good way to start, is to contact your human rights tribunal or commission and say, so, you know, check their website. They often have an FAQ, and you can look at that. And I may just add one final little point. Human rights legislation can also be invoked typically for individual complaints of discrimination, obviously. So that, you know, if you're a prof and people are treating you or sticking a label on you, human rights legislation can also be a recourse. That's a whole other area of the law, but it certainly can be something as an individual that you can look into for protection.
Yeah, and that actually, I think a lot of universities now have human rights officers. I think it's a fairly standard role in academic institutions. So that's actually helped in terms of getting another person on the ground within the administration who may or may not be actually tied to the administration, or maybe working independently, say even of the university, who would be a good source of information and advice if there's a situation where you feel that is happening. So that's another option that I think has been, at least at my institution, has been relatively new, but fairly positive.
We have a question. What if I retweet or share on social media a defamatory remark made by someone else? Am I still liable in that case?
So I'm going to go back to the gray zone, the posts and hyperlinks. That is the test when you're retweeting, reposting. Merely transmitting information is not publishing. So even if the content is highly defamatory, you will, at the end of the day, will not be held liable for it. As long as you are not expressing it, adopting it, or endorsing it. So, you know, if you were to retweet something and say, you know, check this out, you're probably crossing that line. If you're being critical and saying, you know, can you believe this person said this, then you're fine, because you're not adopting it or endorsing it. Clearly, you're expressing a contrary view. If it is content neutral, typically you are on the safe side of publishing, in the sense that you are not deemed to be publishing the content if you are just sharing it. And
Yeah.
On this, I think the law will probably evolve. The quote that you have there on the screen is from 2017. It is very recent, but it is. That's where essentially we stand right now.
Yeah, yeah. And can I just add, one of the things I've come to do as a force of habit, almost, or as a kind of habit from learning about this material, is I'm much less apt, maybe I'm more cautious now when I post things, but I tend to share it and don't say a whole lot unless I have some very strong opinion that I feel comfortable sharing, but I'm much more apt to simply share. And that's something that I think is interesting, because it's something that having done this work with Stefan on this document and on these slides, it's made me much more acutely aware, in all senses of the world, all puns intended, about how we as an association share information, but also what the kind of threshold is for being challenged on that information. And so it's probably much safer in many cases to simply share it. And that's not to say that there shouldn't be robust debate, but I think there is a way in which we have to be careful about being freewheeling on the internet, to put it bluntly.
Okay, another question. In the case that a person is being sued for defamation because they came forward about their experience of sexual assault or harassment perpetrated by the plaintiff suing them, how would the defendant prove in court that their allegations are true and therefore justified in the case that there has been no criminal law proceedings beforehand? What kind of evidence goes into proving factuality in such a case?
That's a tough one. So, first of all, reporting as a victim, or if a victim comes to you and you feel obligated or comfortable reporting that kind of information to the authorities, whether administratively within your institution or to the police, is completely fine, obviously, or else nobody would ever go to the police, because they would always be afraid of being sued. So, and in fact, you may be required under your human rights policies to report these things. So reporting and creating an unpleasant investigation into the person's behavior is not an issue. That said, if it comes out into the public realm, right, that becomes the publishing part. There's nothing preventing the person, the alleged perpetrator, there's nothing preventing them from suing. And that is really the unfair part, and the law, unfortunately, is not always fair. So from a process point of view, you may be facing that lawsuit. Your lawyer would likely go to court and ask that it be suspended until either administrative proceedings are finished, or until the criminal investigation is finished. But remember one thing is that when it comes to a civil lawsuit like this one, and if this were to ultimately go to court under this scenario, I've been sexually assaulted by a colleague, I've spoken up about it, the colleague is suing me, the judge will have to, in a civil suit, choose which version of the facts is the most likely, the most credible. So that's the test. So it doesn't speak to how this is going to be, the story will end, but that is how the law would approach it. This is, in a civil lawsuit, this is not the beyond a reasonable doubt that you see in criminal cases. So the judge would simply look at the evidence and choose which version is the most likely. So it does not remove any of the unpleasantness, and it does not prevent a very unfair lawsuit from going forward to try to shut you up. But for that to happen, it has to go into the public realm. You can go to the police, have an investigation begun. That is obviously your right.
Thank you.
Stefan, can I just say one thing about this? Just one of the issues around this, I think, is that there have been situations where individuals have been investigated for sexual assault and the reports have remained confidential, and the investigation was done through a university or an institution of higher learning, but did not ultimately end up on the police doorstep for whatever reason. So one of the questions, or one of the things I suspect that is behind that question is, what do I do when this particular report, which factually may spell out, yes, these things happened, is not publicly available? And I'm not sure that there's much that can be done other than that a lawyer can, I guess, point out that context, that this is what happened, this is what occurred, and that, for instance, that person who was charged or was accused was then, after the fact, you know, in some way found guilty or seen as having been a problem because they've been fired or let go. So do you see where, so I don't know that there's an easy answer to that, but I think that's one of the issues, is that sometimes you'll be dealing with proceedings that went through a university that are confidential, where you don't have access to the facts in a way that you might have through a police investigation.
Jennifer, thank you for your comments. We understand that I think you have a teaching engagement to get to.
I do. I have to teach for 3 hours now.
So thank you very much for walking us through with the very pertinent questions that you asked. We will go to just one final question, but great. Jennifer, thank you for guiding us through these reflections.
Okay, thank you so much. I really appreciate it, and I hope everyone enjoys the webinar who listens to it. And thanks, Stefan, in particular.
Thanks, Jennifer. I had a it was very fun to work on this with you and develop something that was helpful.
Yeah, we got to find another project. Thanks.
Yeah,
bye.
Definitely.
Have a good class.
Thank you.
All right, so we have one other question. What about the responsibilities of an academic association for a defamation suit coming against an individual as a result of an event at its meetings? What support can or should an association offer?
So the legal answer and the practical answer are going to be a little bit different. So if you're organizing an event and you have a speaker come to that event and the speaker says something problematic that crosses the defamation threshold, obviously the speaker is publishing, it's their responsibility. There is a chance that the organizers, if they knew what was going to be said, could be on the hook as well for the publication, for the content. If the organization did not know that this specific comment was coming, the likelihood is a bit less that the organization would be on the hook. If a speaker is being sued, typically the organization would have no obligation to that person. So I don't know if that fully answers the question, but can you repeat it perhaps, Sonia, just one more time?
Yeah, so one more time. What about the responsibilities of an academic association for a defamation suit coming against an individual as a result of an event at its meetings?
Right. Under law, there's no automatic liability for that. It would be a much more factual review of how much the organization knew in advance and what control they had over that.
Okay, thank you. With that, we are at time. Again, a really big thank you, Stéphane Emarchabot, for your expertise,
my pleasure.
For the time you've put into this, and for making this content come alive for our members. Thank you to Philip and Lorna and Lily, and of course, a big thank you to Jennifer, who's now off teaching, and a reminder to our members that this was actually a member-initiated webinar, and it's of value to the Federation to know what kind of topics are of interest to our members. So thank you to Jennifer and Acute for having voiced this and for having worked so hard alongside Stéphane. So again, thank you very much to all of you. And please download the material and refer to it and share it with your colleagues. Merci, Stéphane. Thank you.